Here we are.
Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon. Welcome to all counsel and also to all those who are watching on our Supreme Court Live channel. I want to begin today by making a few introductions, as we have some faces that are not often or usually seen when our court hears argument. We'll begin with our new colleague, Justice KJ Wall. Today is his first day of hearing argument with the court. We are excited to welcome him to the bench and to begin this period of our court's history with him as a justice. As many of you may know, we face a change this week with the impending retirement of Justice Carol Beyer on Friday of this week. And because of that upcoming retirement, she is not sitting with us this week. We are fortunate to have sitting with us Senior Judge Mike Ward. Judge Ward has acted as a senior judge for the court since March last spring. Before that, Judge Ward served as a district judge in the 13th Judicial District, which is made up of Butler, Greenwood, and Elk counties. He served in that position since 1999. Also, we have one of the justices who recused from today's case, Justice Wilson. It will not be sitting with us today. And sitting in her place, we are thankful to have Judge Eric Comer from the Sedgwick County 18th Judicial District, where he hears civil cases, join us. We very much appreciate his joining us today. We know that the courts are becoming quite busy as they try to deal with the cases in their local courts. So we appreciate him taking time out of his busy schedule to help us out. So, all of these, Judge Ward and as our visiting judges will listen, not obviously to the oral arguments today, participate in all deliberations, and will also participate in all other processes that lead to the decision of these cases. And they, like all the rest of us, have read your briefs and are looking forward to counsel's arguments. I will now ask the clerk of the appellate court, Mr. Doug Shima, to please call the case. Mr. Shima?
Thank you, Your Honor. May it please the court. The 1 p.m. docket for Monday, September 14th, 2020 consists of one case, appeal number 118035, JAYHAWK Properties LLC and Heartland Park Raceway LLC versus the City of Topeka, Kansas. Shawnee County briefs both sides. The City of Topeka has reserved 5 minutes of rebuttal time. Your Honor, we're ready to proceed.
Thank you. Will counsel please state their appearances and indicate the parties that they represent?
Please support.
Oh, go ahead, Wes.
Thank you. I'm sorry. May it please the court. Wes Weathers on behalf of JAYHAWK Racing, the appellant.
And also, may it please the court, Cynthia Shepard on behalf of JAYHAWK.
It please the court, Thomas V. Murray and Catherine P. Logan, representing petitioner the City of Topeka, Kansas.
Thank you, counsel. This is sometimes a procedurally difficult thing where we have an appellant who is not necessarily the person who brought the case to us on petition for review. So in this situation, we do have the appellee with the initial argument. As I understand it, Ms. Logan will be presenting that argument, if you would like to proceed.
Yes, sir. Yes. May
Thank
it
you.
please the court. This case is about whether elected city officials can contract away their governmental powers relating to municipal finance, taxation, and economic development. Under long-established Kansas law, they cannot. As aptly stated by the district court, a government entity cannot contract away the ability to change course in the exercise of governmental powers, notably because the decision might be necessary for the public good. Appellants argue that the general principle does not apply to the Memorandum of Understanding, or I'll refer to it as the MOU, because TOPEKA did not promise to issue star bonds, but only to make a good faith effort to do so. As a matter of fact, this whole lawsuit is an effort by appellants to create a claim where there was no duty to begin with. If the city did not promise to issue star bonds, appellant's claim fails because there was no obligation to which a duty of good faith could attach. Moreover, the promise to use a good faith effort does contract away a governmental function because it takes away the absolute discretion to act in the best interests of the general public welfare and imposes a duty to act in the best interest of another party to a contract. The Court of Appeals' erroneous decision that the issuance of star bonds is a proprietary function which may be contracted away has significant adverse impact on cities in Kansas. Faced with potential damage claims resulting from this holding, cities would no longer be able to enter into purchase contracts contingent on star bond financing without risking damage claims if the city decides it's necessary for the public welfare not to finance a purchase with the issuance of bonds. The compelling and well-reasoned decision of the district court correctly applied Kansas law to the facts of this case, ruling that the issuance of star bonds is a governmental function which TOPEKA impermissibly contracted away under the MOU, thereby rendering the MOU ultra vires and void and unenforceable.
Is the issuance of star bonds always a governmental function? Is there any
Yes.
exception to that? It is always a government.
Yes, Your Honor, it is always a governmental function.
So it's the inclusion of the star bonds in the memorandum of understanding that makes this essentially the inability of the city to contract away that interest. I mean, had it been a different funding mechanism, where would we be today?
Well,
Let's say it was general and revenue bonds, or if it was another means of financing this understanding, would we be here today?
It depends. Probably we wouldn't be. If it were a revenue bond, we certainly wouldn't be, because revenue bonds are paid solely by revenues from the project itself that's being financed.
Initially, that's how the project was financed in 2005, was through revenue bonds, wasn't it?
No, that's incorrect. The project was originally financed with full faith and credit star bonds.
Okay.
This would have been a second series of star bonds to finance the racetrack.
Council, at the time when, on May 2015, when the city council considered the resolution and rejected it, what was left to be done to complete the transaction that had been agreed to?
Nothing. I mean, the transaction was contingent upon the issuance of star bonds. So without the issuance of star bonds, the underlying transaction, the contingency for the underlying transaction didn't occur, and the obligation of the city to purchase the property was extinguished.
So the issuance of the star bonds was the last act in this transaction, and that's where they pulled the plug on this thing. Is that the deal?
Correct. That's correct, Your Honor.
what was left to be decided on the issuance of the star bonds? Were we just down to interest rate and the commercially reasonable aspects of issuing the bonds?
At that time, the city would have had to gone out for public bid for the issuance of the bonds. That would have created a situation where multiple entities or parties would have submitted bids for the terms of the bonds, and ultimately the governing body would have had to decide whether or not to issue the bonds under any of the terms that were offered and available.
But the parameters for making that decision were contractually the commercially reasonable terms.
That is what the, now that's not really exactly what the MOU said, but assuming that that is implied in this contract, the governing body still retained should have retained the sole and absolute discretion to determine what terms were acceptable to the city, but moreover, and as importantly, the discretion to determine whether star bonds should be issued at all to fund this project.
What then is the meaning of paragraph 10 of the MOU with the parties' cooperation that make a commercially good faith, reasonable effort to accomplish the objectives of paragraph 8, which included the star bonds provision?
Well, I think that there were certain aspects of what the city, of the steps for issuance of star bonds that the city had to take in order that this could apply to, the good faith agreement could apply to. For example, it's the city that had to apply to the Kansas Department of Commerce for permission to issue the star bonds. The city has to prepare a feasibility study relating to the issuance of the star bonds. The city has to schedule certain public meetings so that the issuance of the star bonds can be discussed at public hearings. The good faith duty can apply to those sort of administrative steps that the city has to take, but it can't apply to the ultimate decision to issue those bonds because, as we fully briefed and as the court is aware, it's the district court correctly held that the issuance of the bonds is a governmental function, and the city has to retain full and absolute discretion over that final act and decision.
Is your answer that, just to see if those tasks would have to be done regardless? Those tasks of going through the various steps for the issuance of the bond, are you saying those had to be done even if the city did not plan to issue the bonds to be commercially reasonable?
No.
Or are you just saying if that decision is made, then that's the only steps that the paragraph 10 would apply to?
Correct, yes. So it was an agreement to basically initiate the procedure that because of the way the Star Bond Act is written, there are so many steps, you can't decide at one meeting to issue star bonds and then issue them. You have to go through these multiple steps, which are in essence administrative in nature. Does that answer your question?
Yes.
Now I'd like to turn to where the Court of Appeals went astray in its decision not to follow the district court. Manifestly, TOPEKA's power to issue star bonds is the exercise of a governmental function. And the district court decision, our briefs, and the briefs of the League of Kansas Municipalities detail why this is so. So I'm not going to go through all of those separate bases for that determination.
Counsel?
Yes.
Yes. While you're on that point, my question is more to the framework, how we analyze this question. The contract challenge is not one of sovereign immunity or statute of limitations from which this governmental versus proprietary function derives. It's really, as I understand it, a challenge that it's ultra vires because it infringes on a core government function of the sovereign or the political subdivision in this case. And if that premise is correct, isn't this really a question of that should be analyzed under the reserve powers doctrine without regard to the old common law governmental versus proprietary function analysis?
Well, I'm not sure that the reserve powers doctrine differs from the, in this case, from the governmental powers versus proprietary, although I do believe that Kansas law is that the city of Topeka did reserve the power ultimately under the Star Bond Act. They had to reserve the power ultimately to decide whether or not to issue these bonds.
But under a reserve power analysis, arguably, it's debatable, but the question is whether it forbids the municipality from exercising a reserve power rather than compelling it to exercise such power. And in this case, there's no power that's being inhibited, is it?
Well, the discretion of the governing body to make the ultimate determination of whether or not to take this act, to make the determination of whether or not to take this act is in the best interest of the residents of the city is inhibited.
So your position would be there's really no functional distinction, if it's a reservation of powers question, between a contract that forbids a city from exercising its reserve powers versus exercising those powers.
At least under these facts, I don't believe there is a valid distinction.
Thank you.
Because at the end of the day, the purpose of the city governing body being able to retain that discretion is to exercise it for the benefit of the public rather than for the benefit of a private party to a contract.
Thank you.
Council, let me jump in here and piggyback on Justice Wall. What would happen if the MOU did not have paragraph 8 about the contingent star bond issuance?
Okay, so if the contract wasn't conditioned on the issuance of star
Right.
bonds, you mean if the city had just contracted
To
to
buy
purchase the property and the contract didn't address how it was going to pay for it?
Correct.
Is that your question? Okay. Well, in that case, a cash basis analysis would be appropriate, because if the city absolutely contracted to purchase the property, then the city would have had to have funds on hand and budgeted for the purpose for paying for that. But assuming cash.
And that gets to my follow-up question, which is the question I really want to ask, which is, would you be making the same argument here if the council had just said, we change our minds, we don't want to purchase this property? I'm trying to figure out why is that not a discretionary governmental function, whereas the issuance of star bonds is?
Well, without the issuance of star bonds, a city does have the power to acquire property. And if a city enters into a contract with a third party to purchase property, separate and apart from the star bond feature, it isn't necessarily a governmental act.
Why is that, though? That's the question I want to ask. Why isn't paying for property? Why does it matter how the property gets paid for?
It matters because if it's paid for by star bonds, the Star Bond Act itself, which is the sole authority that the city has to purchase property financed by the issuance of star bonds, the Star Bond Act itself manifests that this is a public purpose and a governmental purpose, and any actions delegated to a city under the Star Bond Act, including the purchase of property to be financed with star bonds, is per se a governmental action. And that's what the district court correctly held. Does that answer your question, Justice?
Well, not exactly, but I understand your answer. I'm just hung up on trying to understand analytically why your argument as to what's a governmental function would not equally apply to a circumstance that did not involve star bonds. Because
Could
the
I continue?
expenditure of public monies, isn't that a governmental function as well?
Well, not always.
Okay.
It isn't always a governmental function, but here we're expending money. The city would have been expending money through a mechanism that includes the ability to impose special taxes under the Star Bond Act, and that makes it a governmental function, that kind of financing. Should I continue?
Are there additional questions?
I would ask council, how does the issue that this involved the potential for, with star bonds for tax financing, interplay with the question of whether this is prohibiting or limiting about an act?
Well, the fact that star bonds can, they affect taxes in two ways. One, under the Star Bond Act, cities can use or designate certain of their sales tax revenues to pay for certain expenses that are authorized under the Act. And in this case, because the proposed star bonds were for full faith and credit star bonds, the city, by issuing those bonds, would have been obligating itself to impose ad valorem property taxes on its residents in order to pay for, repay the debt represented by those bonds. And taxation,
Go ahead.
taxation is clearly a governmental power, which the city is exercising when it issues full faith and credit star bonds.
I saw in the that the indication is that you're arguing that it's because it's full faith and credit bonds. I didn't see anything in the MOU that indicated that these were full faith and credit star bonds. Is that because is that claim because the initial issuance of star bonds back in 2004 or 2006 were full faith and credit star bonds, that these additional star bonds had to be full faith and credit?
They didn't have to be, but that was the contemplation of the party. And as a practical matter, there would have been no market for these bonds if they had not been backed by the full faith and credit of the city. That was contemplated. I don't have the MOU in front of me, but I'm absolutely certain that both TOPEKA and the appellants always intended that these would be full faith and credit star bonds.
Thank you.
Are there other questions? Mr. Weathers?
Thank you. Thank you, Justice. I read last night, or looked last night at our brief file here, and it appears to me that we've written, including the Court of Appeals brief, some 14 briefs that are before you. There are large issues and small issues that have been addressed over and over and over, but we think the starting point for this determination is to look at it in this context. The ultimate question here is whether a municipality can be held to an obligation that it willingly contracts to undertake, and whether a municipality can be required to be a reliable contracting party. The Court of Appeals observed that local governments, like any other consumers, sometimes need to procure what is needed. And they must do that by selling, they must do that with those who sell the same products. In other words, municipalities are just like all of us. There are things we need, and some of these things we need to contract for. If the contract is, as the Court of Appeals here found, proprietary under cases in Kansas like Krantz and the Newman Hospital case, then that contract is binding on the municipality. Now, the background of this case, the facts of this case, I think would be helpful to reflect on just briefly. Essentially, what happened here is the city, because of the 2006 Star Bond issue, was having some financial problems. And the city wanted to resolve those problems, and the city decided that the way to do it was to acquire the interest in the property of my client, the so-called reversionary interest. The parties set out to negotiate and ultimately reached a highly publicized agreement. At that point, my client had been trying to sell its interest to a third party. Because of the contract that the parties reached, my client withdrew from attempting to sell it to someone else because it had contracted to sell it to the city. And we
Mr. Weathers,
Yeah.
is
Yeah,
the
sure.
memorandum of understanding synonymous with a sales contract for the racetrack? Seems to me it's two different things, but Court of Appeals thought it was a contract for sale, but isn't it different than the memorandum of understanding has with it certain contingencies qualifying? What would have happened if under the memorandum of understanding, let's say the Department of Commerce didn't make the proper designation and the city was not eligible to acquire the Star bonds? Would they still be obligated to go forward with some other financing? You could sue for breach of contract?
Well, I'd answer your question this way. It was always contemplated that this was going to be done through the issuance of Star bonds. That was the city's choice, not my client's choice. Now, as far as the issuance of these Star bonds is concerned, the reason that the parties agreed to the contingency clause was that it was understood that there could be issues such as the kind of thing that you bring up, Your Honor.
Yeah. So what happens if that would have happened, if that would have occurred?
If there would have been, and I want to make my answer a little broader than your question. If there would have been a problem that arose with the issuance of these bonds that made them unreasonable for the city. In other words, the interest rates weren't appropriate or the terms weren't appropriate. If that had occurred and the city had done all it was obligated to do under the MOU, then we probably wouldn't be here. But what happened is we never got to that point because after passing a resolution to issue the bonds, and in the resolution, the city obviously understood that it could meet all the compliance standards by the end of the month of December. If that had taken place, obviously we wouldn't be here. But let's say, if it took place, if they tried to sell the bonds and there were problems that came up with the sale, and they could reasonably come back to us and say, for these reasons, we've done all we can to reasonably attempt in good faith to comply with the contract, but we can't do it. But we don't have, if that were to happen, we probably would not have a lawsuit. But the problem here is that's not the case. They can't point to one issue such as you've raised or one issue such as I've mentioned in terms of market issues or interest rates. There's not one of those issues they can point to as being the cause of their withdrawal from this contract. Instead, they made a political decision. Instead, what happened was I hesitate to get too much into the facts because as you know, we really just started this lawsuit. The answer hasn't even been filed in the case below. But what happened was the MOU became a political issue in the city of Topeka, and a petition was passed and passed around for execution or for signatures by.
Counsel,
Yes.
I'm
Yes.
just going to interrupt you. I'm sorry. It's awkward to interrupt on this format. I agree with you that the facts reflect that this became a political issue.
Yes.
My question is, isn't the discretionary governmental function doctrine explicitly designed to protect the political functions of government entities? In other words, it doesn't strike me as the fact that this was a political decision that was entered into by new council members who were elected after this became a public controversy. It doesn't strike me that that helps you. And in fact, that suggests to me that the decision to not issue these bonds was explicitly political, and that's what we're trying to protect.
But the issuance of the bonds was made contingent upon the city taking all reasonable steps it could to issue the bonds.
Well, counsel, the question, if I can follow up there, is, well, if the city had taken those steps or taken further steps and then decided not to issue the bonds because they couldn't get the right interest rate or whatever other circumstance there would be, and you're saying that there probably wouldn't be a lawsuit, then what damages does your client have for the fact that this happened the way it did?
What I'm saying is the issue, if some other factor had arisen other than the city just decided to withdraw from this process, that would have then had to be looked at in the context of paragraph 8, the contingency clause. But the city in no way has met that obligation of doing all that it reasonably could to pass the bonds. We don't think just a pure political issue of now the folks don't sound like they like this idea. That's not a reasonable, rational reason to withdraw. That's part of being in government.
But the underlying motion that was filed in the district court was a motion to dismiss for lack of or failure to state a claim. At some point, you've got to get the damages, and I'm just trying to see if we were to send this case back to the Court of Appeals or back to the district court, do you get the damages?
Absolutely. We believe we would be entitled to damages. Your Honor, there is no reasonable basis that these bonds couldn't have been issued. When we talk about a political issue, it's just that the city changed its mind. The city, under paragraph 8, didn't maintain the right to just change its mind. The city had an obligation to go forward and to do all it could reasonably, commercially reasonably, to issue those bonds. And in the meantime, my client, as I mentioned earlier, had totally taken the property off the market, and the net result of this was my client lost all right, title, and interest to Heartland Park, just as the city did, and neither got any compensation for it.
But if the contract had been followed through, your client would have lost title anyway.
No, if the contract had been followed through and the bonds had issued, we would have had a contract, and yes, we'd have lost title because the contract was executed, we were paid, and there was nothing yet left to do. The problem is, and And in part, this gets to what in Kansas law is called the Prevention Doctrine. One party to a contract can't simply fail to do something that it's obligated to do and then assert that since these things didn't happen, there was no duty. The city is the entity to this contract that completely walked away from its obligations and didn't attempt in good faith to issue the bonds. And that's what they contracted to do.
Are you saying that a government entity can't ever change course in a decision that's made such as this? Let's take it out of the context of a racetrack, and let's just say the city is thinking that based upon some big corporation, let's say Google announces that they're coming to Topeka, they're going to bring 50,000 employees or 25,000 employees and families. And then the city, as a part of that expectation, it contemplates issuing bonds to build some schools to accommodate the new population. And they're in the process, they go through the effort, and then Google backs out. Are you saying that the city still has to fulfill that obligation? And I appreciate that there's a difference here, but it just seems to me that there's an inherent power in a governmental entity to change course if it wants to, and depending on certain factors. And I just, how is that any different, just in terms of the capacity for a governing body to change course?
The municipality loses that power in a contract that is deemed a proprietary contract under Kansas law. If this is a proprietary contract, as the Court of Appeals held, and as we firmly believe and have written brief after brief to support, the contract is binding. It's binding in the same way as if Amazon contracted with Microsoft to do something and then decided, well, we just changed our mind.
And the method of financing makes no difference. So that's part of the distinction here, is that when you look at star bonds and when you look at the financing, or what a government entity can do, is that the issuance of star bonds to finance something is something Google can't do. It's something Amazon can't do. It's on, right. And so the ability, the taxation function is I think is what makes this distinct and what makes this a government function. I don't see how it's not.
Well, the government function that's involved here, as we continue to assert, is the obligation to do its very best reasonably to issue these bonds. And there's Kansas law that permits a contract to issue bonds. The Brown-Crummer case that we cited to you, for example, is one of those cases. In that case, a municipality contracted to issue bonds and then decided it didn't want to, probably an interest rate issue. It was not totally clear why. But the court said, no, you've contracted and it's a proprietary contract and you're bound to it. And then the city, of course, has statutory authority, as we know, to buy property. It exercised that authority. It chose a manner of attempting to fund it. And the parties worked out an agreement where the city accepted and undertook that it would act in commercially good faith and do its very best to issue the bonds. Did that answer your question, Your Honor?
Yes. It addressed my question.
Well, let me try to approach it a different way, because I want to answer the question.
I think the answer that I asked the city is always the issuance of star bonds, a governmental function, answered yes. I still don't think you've
Well,
You've answered
all right.
that. Or
Your Honor, we disagree with that. The issuance of bonds is not always a governmental function, as the Court of Appeals held. If you have entered into a contract to buy property, and then the city chooses as its method of funding that contract the issuance of bonds, there's no Kansas cases that says in a proprietary contract of that sort, a city still has the right to just decide we don't want to do it.
Why isn't just the spending of public monies always a government function?
Well, because there are things that the government does, as I started out to discuss here, that are just like the ordinary taxpayer. They want to dis real estate, for example. So they've got to go out on the market and buy it. Kansas law.
The case law supports the answer you just gave.
Yes.
We have this distinction in our case law, proprietary versus governmental. And just like I was asking your opposing counsel, I'm just kind of exploring whether that distinction actually makes sense.
You mean the distinction, the governmental versus proprietary distinction?
One way to put it is are there objective standards which courts can utilize to decide when the expenditure of public money is fundamentally governmental in nature versus proprietary in nature? Because
yes.
I'm having a hard time seeing what the test is.
Well, the test is as described in the Newman case and the Krantz case. There are clear standards that are to be followed in a situation like this. And there's a broader issue here that I tried to address at the outset. If the ultimate determination is that a contract, that a municipality can simply walk away from a contract like this, how is anybody ever going to be willing to contract with a municipality for some of the things it wants or needs? And as we know, the municipalities are constantly in the business of acquiring things, of hiring contractors to do important things. If none of those contracts were enforceable, how would they proceed? There has to be a distinction where if the contract meets the criteria of proprietary, the municipality is bound, just as you or I would be to a contract we make with Walmart to purchase something.
Does the nature of the star bond create a distinction with the cases that you cite that use other bonds and indicate that the government can still be liable for a proprietary contract? And the reason I say that is just because of language that is included within the statutes that relate to the star bonds, which seem inherently governmental, talking about the good of the people and the, much of the language that we typically would see in a governmental function type of scenario. Does that take us to a different place?
Thank you for the question. That was on my outline to discuss here. The city makes much of the introductory portions of the Star Bond Act about it being in the best interest of the state. And obviously, the Star Bond process as a whole is for the best interest of the state, allowing a diversion of sales tax to fund projects that are beneficial to the state and to the entities that undertake the project. However, once a entity, a municipality, decides it wants to pursue a star bond issue, that then becomes a local matter that no one else is involved in that process but the local entity, here the city of Topeka. And in this case, particularly, that's the case, because the only reasons that the city was willing to enter into this contract was because of problems, financial problems it was having. And the money to buy out my client was money that then was going to be paid by the bonds. And at the same time, the city was attempting or intended to expand the 2006 Star Bond project to have a broader tax base. So everything the city was doing here was to cure its own financial problems. The Heartland Park was already here. Heartland Park was already providing the services that had been intended when the 2006 $10 million issue arose. All that happened here was the city made a bad deal when it did the 2006 project. It miscalculated the size of the bond district, and thus it was having financial problems that were plaguing it. And so the city used this opportunity to buy my client's property and then to package all this together to sell. Their idea was if they could package the total title, they could sell it to a third party and at the same time expand the Star Bond District and help pay off the bonds. So this was the quintessential local project.
Are there other questions of council?
Just briefly, Your Honor, if I can have one more
Sure.
follow-up. Municipal contracts are a little bit of a different animal because you enter into the contract charged with knowledge of the limitations of the municipality. And one of those limitations are, or would include, that you cannot contract away the inherent powers of the sovereign or the inherent powers of the governmental entity. And so I guess ultimately the question here is, does this contract impede upon the inherent powers of the municipality in affecting or limiting its ability to issue the bonding?
Not at all. And I think the same case law and doctrine you're talking about is also pretty clear that while there are some functions, some core governmental functions that a government can't contract away its right to exercise, the law is also clear that a governmental entity can agree to exercise one of its governmental powers in a binding contract. And that's what they did here. They agreed to exercise its permissive right. The city agreed to exercise its permissive right to issue Star Bonds and bound itself to do that if possible, through reasonable efforts.
Thank you.
Other questions? Thank you, Mr. Weathers. Ms. Logan, you reserve 5 minutes.
Yes, thank you, Your Honor. I'd like to point out a factual issue here that's been sort of overlooked in Mr. Weathers' presentation, and that is that the property itself was subject to foreclosure by a bank. And as it relates to the MOU, there was a separate agreement with the bank to put the property in a standstill agreement with deeds in lieu of foreclosure held by the bank. So the appellants didn't have the absolute right to sell the property free of any encumbrances to the city. This agreement wasn't just for the city's benefit, it was also to help the appellants out of debt that they had gotten themselves in. As it relates to the governmental function, I want to focus on one aspect of the Star Bond Act that I think is very important, and that is the Star Bond Act, which, as some of the justices have correctly noted, is for the benefit, expressly for the benefit of the citizens of the state as a whole. It's not just a local matter. The Star Bond Act authorizes star bonds to be issued only to pay for certain expenses. It limits the expenses that cities can use star bond proceeds to pay for. The acquisition of property in a star bond district, as was proposed here, is one of those expenses that is permitted. But the fact that the Star Bond Act itself limits the expenses that can be incurred by a city, and the fact that this purchase is one of the authorized expenses under the Star Bond Act indicates not only that the issuance of star bonds is governmental, but the actual purchase of the property proposed in the MOU was a governmental function. Because absent the Star Bond Act, the city could not have used star bonds to purchase the property. It wasn't an ordinary purchase of property. So that's an important point. I also want to emphasize, as we've cited in our briefs, that the law is clear in Kansas and well settled that one who contracts with a municipal corporation is bound at his or her peril to know the authority of the municipal body. And if the municipal body doesn't have the authority to contract, there is no remedy. That's the law in the state of Kansas, and that was the risk appellants took in entering into the contract. I have no further comments.
Are there additional questions for council?
I have one question, a curiosity. When I went to the end of the Star Bonds Financing Act, I saw that it is set to expire. Actually has already expired on July 1st of 2020. Was there any action in the legislature to reenact it or reissue some act like that? Is the city anticipating that for the future?
I'm not aware of the status of the legislative
Okay.
handling, Your Honor.
Okay, thank you.
Anything else?
Could you explain to me again, what is the inherent governmental power that's restricted in this contract?
The power to decide whether or not to commit the government's taxing power by issuing full faith and credit star bonds, as well as the use of the star bond statute to acquire property and issue star bonds.
Thank you.
Judge Ward, were you moving to ask a question? I think you're still muted. Judge, you're still muted.
Yeah.
Judge Ward, you're still muted.
Let me start
Sorry.
again. Could the city of Topeka have chosen not to pursue the issuance of star bonds and yet still pursued the purchase of this reversionary interest with other financing means?
Not under the MOU. They could have separately entered into a contract to purchase this property, either using funds on hand and appropriated for that purpose, or perhaps other borrowing municipal finance mechanisms.
So their duty and obligation to purchase this reversionary interest was based ultimately on their political decision as to whether or not to issue these bonds.
Correct. And the appellants agreed to that. The appellants agreed in the MOU that it was conditioned upon the issuance of star bonds.
All right, thank you.
Any other questions? Thank you, counsel, for your arguments. We will take this matter under advisement. The court is now in recess until 9 a.m. tomorrow morning. Thank you.
Thank you.
Thank you.